FINRA has a code of procedure used to handle trade practice complaints. FINRA's hearing panel is the first body to hear and judge complaints. Appeals and reviews of their decisions are handled by FINRA's National Adjudicatory Council. Further appeal of a FINRA decision may be brought to the SEC and ultimately to the federal court system. So something that FINRA decides can be appealed to the Securities Exchange Commission, and above them is the Supreme Court. Investigating a complaint. No member can say, oh, our books and records aren't open right now, come back tomorrow. No member may deny or refuse to make available books, records, reports, or anything that FINRA asks for. Failure to provide information shall be grounds for suspension. If there's been a complaint and FINRA conducts an investigation or an audit and they believe that a member firm or its registered reps has violated a rule or a law, FINRA's hearing panel, the Department of Enforcement, will issue a formal complaint and name a hearing officer. Persons accused of a violation must specifically admit or deny guilt within a specified period of time. If you don't, you're found guilty by default, which is so creepy. If the respondent refuses to sign a letter accepting a finding of violation, then you have a formal hearing, which are similar to a courtroom proceeding but cannot be removed to a court of law. So this is all handled within FINRA. Now remember, just because they say that you've done something wrong does not mean you did. You can always stand up and say, no, I didn't. In one of these hearings, you have the right to an attorney, you have the right to examine the evidence, and the right to cross-examine witnesses. You do not have the right to remove it to that court of law. If you go to the full hearing, the hearing panel, Department of Enforcement hearing, penalties for violations of FINRA rules of conduct may be fines, unlimited, censure, public embarrassment. They'll make everything you did wrong known. Suspension. If you're suspended for a maximum of 12 months. They can expel you and any other penalty deemed appropriate. If you are suspended, you must be treated as a member of the general public. If you are suspended, you're still permitted to have a personal trading account. Of course, they can never suspend you from trading for yourself, but they can definitely suspend you from touching anybody else's money. If the Department of Enforcement began their investigations, feel like there's nothing to dispute, the person has definitely done something wrong and it's a minor violation, the Department of Enforcement may offer the respondent what is called summary complaint procedure. So this is only used for minor violations. Summary complaint procedure. So in a summary complaint procedure situation, FINRA would notify the person accused, but we don't call them that, we call them the respondent, in writing of the charges. If the respondent agrees, they're basically saying, I plead guilty, and you waive, as the respondent, the right of appeal. The maximum penalty under summary complaint procedure is censure, so public embarrassment, and or a $2,500 fine. Now remember, if you go to that full hearing, the maximum fine that can be imposed upon you is unlimited. You don't really want to go to that hearing. Summary complaint procedure. So you plead guilty, waive the right to appeal. The worst that's going to happen is public embarrassment and or a $2,500 fine. FINRA rules related to complaints, investigations, and sanctions. For the purpose of an investigation, complaint, examination, or proceeding authorized by the FINRA bylaws or rules, an adjudicator or FINRA staff member has the right to do any of these things. Require a member, person associated with the member, or person subject to FINRA's jurisdiction to provide information orally, in writing, or electronically, and to testify at a location specified by FINRA staff under oath, or affirmation administered by a court reporter or a notary public if requested, with respect to any matter involved in the investigation, complaint, examination, or proceeding. The FINRA staff has the right to inspect and copy the books, records, and accounts of such member or person with respect to any matter involved in the investigation, complaint, examination, or proceeding. Like I said, you can't say, no, come back later. No, you have to cooperate. FINRA staff may enter into an agreement with a domestic federal agency or a subdivision of or a foreign regulator to share any information that's in FINRA's possession for any regulatory purpose set forth in agreement, provided that the agreement must require the other regulator, in accordance with the terms of the agreement, to treat any shared information confidentially and to assert such confidentiality and other applicable privileges in response to any request for such information from third parties. Any such agreement with a foreign regulator must also meet the following two conditions. The other regulatory party to the agreement must have jurisdiction over common regulatory matters, and the agreement must require the other regulator to reciprocate and share with FINRA information of regulatory interest or concern to FINRA. No member or person shall fail to provide information or testimony or to permit an inspection and copying of books, records, and accounts. FINRA has an arbitration procedure. So within the code of procedure, we find the arbitration procedure. It's this idea that people argue, in the securities industry, they argue over money. So once you are involved in this industry, any dispute, dollar amount or non-specified amount, must be handled through arbitration. We're not going to court and wasting everybody's time and money. We're going through the code of arbitration because FINRA says we have to. So firm to firm, registered rep to firm, associated person to associated person, customer to firm, customer to registered rep, maybe even firm to customer if, as part of the account opening procedure, you required the customer to sign a pre-dispute arbitration agreement, which we'll talk about in a minute. So arbitration. So securities disputes must be arbitrated. Now, in a moment, we're going to talk about something that they could do instead, which is called mediation. So mediation is always available. Instead of going through arbitration, you can go through mediation, and I'll tell you the rules about that. Mediation is voluntary. Voluntary. Arbitration is mandatory. So if you don't go through arbitration, you can choose to go through mediation instead. But if you don't want to go through mediation, you have to go through arbitration. So most firms today, before they'll take on a new client, will say, here's the account opening information. As part of signing up for an account with a member firm, the customer most of the time signs a pre-dispute arbitration clause. If there is within new account forms this pre-dispute arbitration agreement, FINRA Rule 2268 requires that the clause be highlighted and immediately preceded with the following disclosure. This agreement contains a pre-dispute arbitration clause. By signing an arbitration agreement, the parties agree as follows. All parties to this agreement are giving up the right to sue each other in court, including the right to trial by jury, except as provided by the rules of the arbitration forum in which a claim is filed. Arbitration awards are generally final and binding. A party's ability to have a court reverse or modify an arbitration award is very limited. The ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in court proceedings. The arbitrators do not have to explain the reason for their award unless, in an eligible case, a joint request for an explained decision has been submitted by all parties to the panel at least 20 days prior to the first scheduled hearing date. The panel of arbitrators may include a minority of arbitrators who were or are affiliated with the securities industry. The rules of some arbitration forums may impose time limits for bringing a claim in arbitration. In some cases, a claim that is ineligible for arbitration may be brought in court. So that's the clause that must precede the pre-dispute arbitration agreement. So it's saying things like final and binding. Final and binding. We are not going to court over this matter. If you want a decision, if you want to know how we reached our decision, you must, as a party, must submit at least 20 days prior to the first scheduled hearing date, request a reason. Otherwise, we don't have to give you a reason for what we decided. What we decided is what we decided, and you will never know why. So 20 days prior, you can request a reason for the decision. So this is all trying to make sure that the customer understands what they're giving up by signing a pre-dispute arbitration agreement. Oftentimes, if the customer won't sign it, the firm won't take them on as a customer. So it's kind of a catch-22 for the customer. You have to sign it if you want to do any business with the firm. Customers must acknowledge receipt of the pre-dispute arbitration agreement in writing, and firms must provide the customer with a copy of the signed agreement within 10 business days of a customer's request to do so. So they only have to give them a copy of the signed agreement if the customer asks them for it, and then it must be provided within 10 business days of a request. Arbitration has a statute of limitations. So arbitration claims must be submitted. So the statute of limitations for an arbitration claim is 6 years. Definitely need to know that. Statute of limitations for arbitration claims, 6 years. Under the Code of Arbitration, if you're named as respondent, you have to answer the statement of claim that's presented within 45 days of receipt. So it's basically you have to acknowledge that you are named in this arbitration hearing within 45 days. So arbitration is mandatory. You don't have to go to arbitration though. You can instead, all items, all disputes eligible for arbitration, which are basically any industry disputes with the exception of harassment or statutory discrimination lawsuits, those are not eligible for arbitration and would be handled through the appropriate court system. So if it was a harassment or an employment discrimination lawsuit, something like that, that a registered rep had with their firm, that would not go through the FINRA arbitration process. But securities-related disputes, not employment. Unless it's an employment dispute about hours worked, that would go to arbitration, or location of, they asked you to move out of town, that goes through arbitration as well. So anything eligible for arbitration can go instead through voluntary mediation. Either party that's agreed to go to mediation may get out of mediation at any time before a written settlement has been reached, as long as they give proper notice. The decision of an arbitrator is binding, but the mediator acts impartially in an attempt to settle the dispute, but has no authority to resolve the issue. So if the parties agree to go to mediation and the mediation fails, the matter may still go to arbitration. So what does the Code of Arbitration require? So we start off with what is called simplified arbitration. Simplified. So no matter who's involved in the arbitration proceeding, if it's firm to firm or rep to firm or customers involved, if the amount of money in dispute is $50,000 or less, it goes through the simplified industry arbitration process. So simplified industry arbitration. So you have to know the amount of money for simplified industry arbitration, and you have to know how many arbitrators. 1. Simplified. Decision is final and binding. Always a question there, for sure. The next level is when the dispute is for an amount of money over $50,000 up to $100,000. So this is the first one, and this one's the same. Simplified industry arbitration is the same no matter who's involved in the dispute. But then when we get to over 50 up to 100,000, then we get a little more complicated. So we're going to have disputes involving member firms. We're going to have disputes involving registered reps or associated persons, same thing. And we're going to have disputes that involve a customer. But no matter what, we've got the same amount of money in dispute, okay, over $50,000 up to $100,000. When the case is involving firms, it will be heard by one non-public arbitrator. So the dispute is involving firms. So it seems fair that there would be a non-public arbitrator. That means somebody that is in the securities industry. One non-public arbitrator will hear the case. Unless the parties agree to 3. So they can agree that they would rather have 3 arbitrators. So it's one non-public arbitrator unless the firms agree to 3. If the case involves an associated person or a broker, registered rep, those are all synonyms, one public arbitrator. So now we've got one public arbitrator. Unless, same rule as before, unless the parties agree to 3. So with the firm's non-public, with a registered rep or a broker, associated person, then we have a public arbitrator. When the case involves an investor, involves a customer, it's one public arbitrator. So that would make sense. If you're the customer, if you're an investor, you want a public arbitrator. Unless the parties agree to 3. So when the dispute is over 50,000 up to 100, it's always one. It's public in the case of a broker or a customer. It's non-public in the case of a firm. In any of those cases, the parties can agree to have 3 arbitrators. If the amount of money in dispute is over $100,000 or is an unspecified amount, these are the rules under the current code of arbitration. So once again, we have different rules depending upon who's involved. Member, registered rep, associated person, broker, those are all synonyms. Public, customer. So when the dispute is over 100,000, in all of these cases, we're going to have 3. Panel arbitration, so there's always going to be 3. So 3. The question is, are they from within the securities industry, which we mentioned before, those are non-public arbitrators, or are they public arbitrators? So when we're firms, what do you think they are? What makes the most sense? Non-public. Now look at this. The default is that there's 3 arbitrators, non-public arbitrators, unless the parties agree to 1. So that's the opposite of the previous one that we talked about, unless they agree to one arbitrator. So non-public arbitrators. When the arbitration case involves a broker, registered rep, and associated person, there is one non-public arbitrator and two public arbitrators on the panel. So one non-public and two public. That's what the Code of Arbitration requires. And then when we get to this one, this is interesting. So FINRA rules are changing all the time. So a few years ago, FINRA changed the rules and said, what we're going to do is there's going to be, for cases involving a customer, the ability for the customer to choose what was called an optional all-public panel. So to get on, in the old rule, to get this panel of 3 arbitrators for a customer's case to be heard by public arbitrators, they had to choose that. The default was that it was what was called a majority public panel. So FINRA did some research, did some studies of what happened with the rule that they had changed a few years back. And what they found was that not always did someone choose. The customer didn't always choose the optional all-public panel. But when they did make a choice, most of the time, if they made a choice, they got the all-public panel, and that the awards that were decided on by the public panel were always more favorable than what was at the time the default, which was called at the time the majority public panel. So I think what FINRA thought originally when they first changed the law a few years back is that, anybody involved, a customer involved in this sort of proceeding, is going to choose the majority public panel. Not the majority, the optional all-public panel, but they found that it just wasn't, they didn't always make a choice. And the default choice wasn't in the best interest of the client as far as statistical information was providing. So they said, okay, that rule didn't work the way we wanted it to work, so we're going to start all over. So this is really a new rule as far as the panel composition method for the 3 parties as far as customer disputes over $100,000 or an unspecified amount. So it works like this. So the parties involved can represent themselves. They can hire an attorney to represent them. They can hire other parties to represent them. They're given a list, 3 lists, and on each list is 10 arbitrators. And the first list is 10 chair-qualified public arbitrators. The second list, I'll show you how this works. So 10 chair-qualified public arbitrators. So it's kind of a longer way to get at what FINRA hopes is a better arbitration panel for the customer, is really what this is all about. So that's the first list, so we'll call that list number 1. List number 2 also has 10. These are just public arbitrators. So different, you have to have certain sorts of credentials to be chair qualified, and then these are not chair qualified, so public arbitrators. They're always looking for people to do this. I always get the emails, would you like to be an arbitrator for FINRA? Not today, but maybe someday. And then we have a list of 10 non-public arbitrators. Now, remember this. What we're doing here is discussing an arbitration proceeding between 2 parties, a customer versus a firm, or a customer versus an associated person, registered rep. So we've got someone who is not in the industry and someone who is in the industry, okay? Now, each party to this arbitration hearing are given lists, the same lists, And each party has the ability from list 1 to strike up to 4. Up to 4 arbitrators from list number 1. So of the 10 chair qualified public arbitrators, either party can strike up to 4. Same thing with the second list, may strike up to 4. So 4 arbitrators may be struck. So just, I don't want them. So that's the 10 public arbitrators. And then for list 3, either party has the right to strike any or all of the non-public arbitrators. So it's a pretty big change. It's a recent change. So if I was the customer, I was involved in this arbitration proceeding, I was defending myself, I would probably choose to strike all of the non-public arbitrators, because statistically, FINRA has told us that if this arbitration proceeding is heard by public arbitrators, it's going to be more in my favor. I will get a larger settlement amount than I would if there was non-public arbitrators involved. Doesn't mean that that's what I'm going to choose, but that's just how it plays out. So the panel composition method is pretty complicated when it involves a customer dispute. We're picking 3 arbitrators total. There are no penalties involved in arbitration. The arbitrator simply determines who is right and who is wrong and awards the winning party the amount due. Monetary awards in an arbitration case must be paid within 30 days of an arbitration decision. So arbitration awards payable within 30 days of decision. We talked about if the parties involved in the arbitration would like to know what the rationale is underlying the award, they have to request jointly an explained decision in writing at least 20 days before the first scheduled hearing date. The explained decision is a fact-based award stating the general reasons for the arbitrator decision. It's the chairperson of the panel that would write the explained decision. Either of the parties can choose to go through mediation instead of arbitration. So FINRA has a code of mediation procedures. The mediation procedures are overseen by the National Arbitration and Mediation Committee of the Board. The National Arbitration and Mediation Committee shall consist of no fewer than 10 members and no more than 25 members. At least 50% of the National Arbitration and Mediation Committee shall be non-industry members. Non-industry members. We know what can be mediated, anything to which the arbitration code applies. The National Arbitration and Mediation Committee must meet a minimum of once a year. The board appoints a director of mediation to administer mediations under the code. The director may delegate his or her duties when appropriate. So, mediation, any dispute eligible for arbitration may be mediated instead. Very important. I know I said it before, but it doesn't hurt to say it more than once. Mediation is voluntary. Requires a written agreement of all parties. No party may be compelled to participate in a mediation or to settle a matter with FINRA or by any mediator appointed to mediate a matter pursuant to the code. If all parties agree, any matter eligible for arbitration, including procedural issues, may be submitted for mediation instead. mediation, the party can represent themselves. They can choose to be represented by an attorney unless state law prohibits having an attorney involved in mediation. Parties may be represented by a person who is not an attorney as well, so may be represented by others unless state law prohibits that. Or you can't have a representation by others that's a person that is suspended or barred from the securities industry, or a person that is suspended from the practice of law. So you can't have a suspended lawyer be your parties of representation by others. That wouldn't work. A mediator may be selected by the parties from a list supplied by the director, with the director's approval upon receipt of the parties' joint request from a list or other source the parties choose, or by the director if the parties do not select a mediator after submitting a matter to mediation. Parties are given information related to the mediator's employment, education, and professional background, as well as information on the mediator's experience, training, and credentials as a mediator. I think I might like that job. No mediator can serve as an arbitrator of any matter pending in FINRA arbitration in which he or she is also a mediator. Nor may the mediator represent any party or participant to the mediation in any subsequent FINRA arbitration relating to the subject matter of the mediation. FINRA, its employees, and any mediator named to mediate a matter under the code shall not be liable for any act or omission in connection with a mediation. What are the ground rules? Voluntary. Any party may withdraw at any time prior to the execution of a written settlement agreement by giving written notice of withdrawal to the mediator, the other parties, and the director. The mediator's job is to act as a neutral, impartial facilitator of the mediation process and shall not have any authority to determine issues, make decisions, or otherwise resolve the matters. When parties agree to mediation, they are agreeing to attempt in good faith to negotiate a settlement of the matter. Mediation is intended to be private and confidential. So we're basically saying, let's do this. Let's get this over with. Let's not fight. Let's agree. Mediation. Anytime there's a party that goes through the mediation process, there are always fees that are owed to FINRA. How much the fee is depends upon at which point are we doing this mediation, but they're all described within FINRA's code. The parties to a mediation administered must pay all of the mediator's charges, including the mediator's travel and other expenses. That concludes our discussion of regulatory requirements for trading. Don't forget, read your key facts, practice your final exam. Good luck.